Yeah, go away. Good morning, Mr. Hitchcock and Mr. Katz.
Good morning.
Mary Ann's going to start moving you into breakout rooms with your defendants. Please take a minute to speak with them. If you're able to resolve it, come back on and we'll put the terms on the record. I know some tenants did file their 539s and are entitled to another stay. That return date will be May the 17th, but we'll take that information on the record. I just want you to start checking your schedules to make sure that that's a day that will work for you. And then for the tenants who are here, when you see invitations to go into the breakout room, please go there with the attorneys. I'll come out when things are ready, or 9:15 at the latest. So if you could get moving through your dockets, I'd appreciate it. Thank you.
Thank you.
Mr. Hitchcock, you've been made a co-host, sir. Please feel free to move yourself into your waiting room or your meeting room.
Okay, thank you.
You're welcome. Ms. Berry, we haven't seen Mr. Bejani as of yet, and the court did not receive your 539 form that indicated that you filed for rental assistance.
I sent it to the court. I emailed it.
When did you email it, ma'am?
I received the email last night, or well, I seen it last night from the one I emailed before, because all my upload my documents didn't go through, so I emailed it again last night.
Oh, so no, okay. I looked yesterday and it was not there. But that's not saying it didn't come through last night. It just wasn't there when I was reviewing for today. And I see it now. It came in at 8:13 this morning. You're fine, ma'am. We'll wait for Mr. Bejani, who's here right now.
Okay, thank you.
Morning, Jessica. Can you hear me? Alexa, can you hear me?
I can.
Hi. You know what? I'm sorry, I forgot to make breakout rooms for Lakeshore. So if you want to just, I made you and Jessica co-hosts. So if you just want to grab, I don't know, whatever open rooms you want. I'm sorry.
Okay, thank you.
Welcome.
What happened to Mr. Bajani?
He was here a second ago.
Hmm. He seems to have absented himself from these proceedings. Good morning, all. It is Wednesday, May 1st, 2024. I am Judge Martin. Today's docket includes landlord-tenant cases only. These are cases that were adjourned from either April the 17th or April the 24th. I am just waiting for the attorneys to arrive to get you matched up with one another so you may have an opportunity to speak. I typically start doing defaults or dismissals at approximately 15 minutes after the scheduled start time. There are only 4 cases scheduled for this 9 o'clock block. So we will get people connected and get the cases called here as soon as possible. Good morning, Mr. George.
Good morning.
Mr. Cass, were you done with Mr. Cullum?
Sorry, made me push a button before I can unmute. Yeah, we spoke. I just have to confirm. He said he submitted the 539.
He did.
Okay, so the 17th, I told him that, I think that was the date you said, right?
Hold on one second. Let me pull him out.
Yep.
This is 2402299 LT Pinewood Circle versus John Cullum. May I have your appearances, please?
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff.
John Cullen here.
Thank you. Today was the day and time scheduled for the second hearing in this matter. The parties have had the opportunity to speak. Mr. Katz, we have confirmed that Mr. Cullum filed his 539 on April the 22nd. Mr. Cullum, have you received a response from Cross Point regarding their application for rental assistance?
I have not. I spoke to them on Monday. They told me I should have a response by the end of the week. I also just informed Mr. Katz that I've been displaced from work since December, but I just recently started back. So I'll be able to be making smaller payments during the week. But I also have a large chunk of money coming in from a previous job that I had done that's supposed to be arriving anytime now. So I'm at the point right now, Your Honor, where I just need a couple of weeks to gather everything up, and I should be able to take care of this.
Sir, because your application for rental assistance remains pending, this court is required to adjourn this matter one final time. That adjourn date will be May the 17th at 9 a.m. back here on Zoom in courtroom number 1, okay?
Okay, thank you very much.
Thank you, Your Honor.
The court staff will mail you notice of that. Have a good day, Mr. Cullum. Good to see you, Mr.
You too,
Katz.
thank you.
Thank you, Your Honor.
You're
I think
welcome.
that's it for me. Have a good day.
This is 2402452 LT Capital Real Estate versus Michelle Berry. State your name for me, please, ma'am.
Michelle Berry?
Ms. Berry, the attorney was here and checked in, and now I don't see him. I don't know that staff received communication from him to explain why he was leaving, but in any event,
I was in a breakout room with him and he said he was calling his client.
well, ma'am, he's not here. This case was scheduled at 9 o'clock. It's now 9:10 by this court's clock. You indicated that you did file your 539. The court did see it. That application for rental assistance remains pending, ma'am?
Yes.
Based on that, this court is required to adjourn this matter one last time. That adjourn date will be that May 17th date at 9 a.m. Court staff will mail notice to you at the address we have on record. At that time, if that application has not either been granted or denied, the court would ask you to discuss the matter with the attorney to see if you're able to resolve it between yourselves, okay?
Okay.
Other than that, do you have any questions this morning?
No, ma'am.
Oh, wait, here he is. Mr. Bejani,
Yes, Your Honor.
I called the case of 2402452.
Your Honor, so I got off the call so I can speak to my client. Is there any way you can place me back in the breakout room with Ms. Berry?
Ms. Berry has, yes, but before you go, Ms. Berry has advised the court that her application for rental assistance remains pending. This court is adjourning this matter over to May the 17th at 9 a.m. Mary Ann will move you into a breakout room if something other than, if you need to come back on the record, please return to the record with Ms. Berry. Other than that, I'll see you on May 17th at 9 a.m.
Right, Judge, but besides that, this is our second hearing and we haven't received, my client hasn't received anything from the court or proof that the defendant has filed anything with the court. So we were seeking a judgment as of today.
I understand that, Mr. Bejani, but the court is looking at the 539 right now. I'm not sure why you didn't receive a copy of it.
The 539 is your application for government assistance?
Yes.
Okay. Well, I haven't received anything. All right, Judge. So I'll see you back in a couple of weeks then.
Sounds good, sir.
Thank you, Your Honor.
Thank you. Mr. Hitchcock, were you ready?
Yes, I'm ready to, on a consent judgment, Your Honor.
This is 2402287 LT. This is Belleville Manor versus Vermette. Your appearances, please.
Good morning, Your Honor. Clifton Hitchcock, Swiss Stack Levine, on behalf of the plaintiff, BC Belleville Manor Property LLC.
Ma'am, state your name for me, please.
Alyssa Vermette.
Thank you. Today is the day and time scheduled for the adjourned hearing in this matter. Mr. Hitchcock, what are the terms of your consent judgment?
Your Honor, the terms are the defendant agrees to pay the total amount of $3,783.89 or move out on or before May 13th, 2024, or the writ may issue thereafter. No money judgment is sought at this time. I've explained the 3-day right of rescission to Ms. Vermette. I can further give you the breakdown of the rent and the costs if you'd like as well, which will be reflected in the judgment I'm submitting that she's authorized me to sign on her behalf.
That breakdown, sir?
Rent, $3,601.21. Costs, $182.68 for a total of $3,783.89.
Thank you. Ms. Vermette, you were able to hear Mr. Hitchcock just now?
Yes,
And ma'am, you were present back on April 17th when this court played a video that explained the rights you have available to you in this landlord-tenant case.
yes,
Do you have any questions about the rights available to you, ma'am?
no,
Do you have any questions about the terms of the consent judgment that Mr. Hitchcock has placed on the record?
no,
Have you authorized his office to sign the agreement on your behalf because you appear on Zoom and not in person?
yes,
He will prepare a consent judgment with the terms he placed on the record. He'll file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else in this matter, sir?
No, Your Honor, thank you.
Anything from you, Ms. Vermette?
no.
You're free to go, ma'am. You have a great day. Good luck to you.
Thank you too.
Thank
Your
you.
Honor.
This is 2401205 LT. This is Arthur Willis versus Alexandra Weed and Don Goldhart. Unmute yourself and state your name for me, please.
Good morning, Judge. This is Arthur Willis.
Good morning, sir. The last time we were here, the court asked that you provide proof of service beyond the posting. Were you able to do that?
Didn't get that from the court last time. The only court just gave me a date because the client didn't show up. The service was made by the courts. They made the they presented the proof. I didn't. They did. I paid the court to do that.
I asked you to move. Like, how are they gonna be able to work with all the shit?
I'm sorry, Joe. Were you speaking to me?
That wasn't me talking, that was someone else. The issue was that there was posting only. There was not court mail and there was no proof of mailing by you.
Yeah,
That
we
was
did
the
all-
issue.
Well, they
I'm
didn't bring-
sorry?
They didn't bring it up last time we was here, and I did all of that. I gave that to the clerk. We got statement from the post office where I mailed it to them in the beginning, and also where the officer from the court carried out the writ to them because I paid them to do that.
The mailing as well?
No, the post office did the mailing. I have a copy of the date that I had the mail sent out to them.
What I'm saying to you is when we were here on the 17th, there was only posting showing. I said to you at that time, there was no proof of court mailing or proof that you done mailing. And I asked that if you had proof of mailing, either by the court or by yourself, that you supply it to the court clerk. And you're saying that you have proof of court mailing of the summons and complaint for this matter?
Yes, ma'am. I
Okay.
had it in.
The
I had
court
it in.
doesn't,
I'm sorry.
go ahead.
No, I had it in, but I just misunderstood what you're saying. I didn't get this far because the client never showed up, and I don't remember that happened. But I'm not saying you didn't do it, because I just probably missed it. So what I do
Okay.
now?
You tell me if there is still rent and due, is there still rent due and owing in this matter? And in what
Yes, ma'am.
amount?
She's not paid anything. $1,200 from the 8th, and then the month of April she hasn't paid anything at all. She hasn't called me, haven't talked to me at all. And I thought this time we going to be evicting her out of the building. That's what I thought this case was for. She didn't show up last time. I'm not sure she's here today or not.
She's not, there's no response to the call. The court's taking defaults. What is the total amount of rent due and owing?
The $1,800.
$1,800 and your total in court costs.
$275.
Submit your default judgment for $2,075 and provide a copy of proof of mailing on the defendants that occurred before our original court date, okay?
Okay, thank you.
And based on your submission of proof of mailing, the court will sign that default judgment, finding that the defendants have failed to appear as directed by this court. There was a notice that was mailed out from the April 17th date adjourning the case over till today. Is there anything else this morning, sir?
No, ma'am, thank you.
Have a good day.
Thank you.
You're welcome. Mr. Callahan, did you speak to Mr. Melville?
I did, Your Honor. We do have a resolution.
This is 2402451LT. This is Redford West versus Ronald Melville and all occupants. Please state your names for the record.
Kevin Callahan for Plaintiff Judge P78273. Mr. Melville, can you state your name for us?
Ronald Melville.
Thank you. Mr. Callahan, what's the resolution?
Judge, we've agreed to a consent judgment with a writ date of May 17th of 2024. Total rent to retain possession is $7,500, which does include May rent. There is $248 in court costs and statutory attorney fee for a total of $7,748, Judge.
Thank you. Mr. Melville, you were able to hear Mr. Callahan just now?
Yes, Your Honor.
And sir, you were present back on April 24th when the court played the video explaining the rights you had available in this landlord-tenant matter.
Yes, ma'am.
Sir, did you have any questions about the rights available to you?
No, ma'am.
Do you have any questions about the consent judgment that Mr. Callahan just placed on the record?
No, Your Honor.
And because you appear by Zoom, this agreement is not signed. Have you authorized Mr. Callahan to sign this agreement on your behalf?
Yes, Your Honor.
Then his office will prepare a consent judgment that indicates that there's $7,500 due in past due rent, $248 in court costs for a total of $7,748, and that you will pay this amount or vacate the property by May 17, 2024. He will file that document electronically with the court. I will sign it, and a copy will be mailed to you at the address we have on record. Mr. Callahan, is there anything else in this matter?
Nothing further, Judge.
Anything from you, Mr. Melville?
No, ma'am.
Then, sir, that concludes this matter. You're free to go. You have a great afternoon.
Thank you, Judge.
Thank you.
You're welcome. This is 2401385LT. This is Spencer Moore versus Bernard Boswell and Caprice Liggs. Would you
Bernard
state your
Boswell.
name, please? Thank you, Mr. Boswell.
Yes, ma'am.
Caprice Liggs.
And Mr. Moore, please turn your video on, unmute yourself and state your name for me, please, sir.
Oh, Spencer Moore present, Your Honor.
Thank you. Today is the day and time scheduled for the adjourned hearing in this matter. When we were here back on April the 17th, the parties had the opportunity to speak to the attorney from Lakeshore Legal Aid. Ms. Liggs and Mr. Boswell, are you being represented by Lakeshore this morning?
No, ma'am.
Have you spoken to Mr. Moore?
Not since the 17th, no.
But I
Would that
had,
be
well,
helpful
can I
for you
say?
to, I'm sorry. Yes, ma'am. Go ahead.
Oh, I'm sorry. Well, we did try to speak with the legal aid last time we were in court, and we didn't actually qualify, I guess, because of our income. So we asked if we could speak to Spencer Moore while we were in court last time, and we did actually speak with him in a private room last time we were in court. I'm not sure if you knew what the outcome was or what we spoke about. or if that's
I
significant.
don't know. I don't know. And then my question was going to be, do you have an agreement? Or do you need to speak to Mr. Moore this morning to see if you're able to resolve this case?
Well, honestly, last time we spoke, he did state that he didn't want any money from us for April and May, which we haven't paid yet because he sent us to court. He just wanted us to, I believe, give him a date on when we were going to leave. So I'm still a little confused
That's-
on why we're at.
I'm sorry, I'm interrupting you because this is just a termination case. It's about a move out date unless you have a defense to this case. So if you would like a moment to speak to Mr. Moore, we can move the three of you into a breakout room. And if you can agree on a date, great. Otherwise, you'll come out, and as soon as I call 2 or 3 more cases, I'll swear you in and we'll be prepared to take testimony in your case, okay?
Sounds good.
Okay.
Your Honor.
Mr. Moore?
Yeah, there's no need for us to go to a room. My decision hasn't changed. I'm just looking for a date they can leave.
Exactly.
Yeah.
That's what I said, Mr. Moore. I said, if the parties want to go into a room and discuss a date, and if you can come up with something, great. Otherwise, you'll come out. I'll call these 2 other cases. Or maybe not. It looks like the attorney's gone.
Eddie.
Mr. Boswell, is there some defense to this termination of Tennessee action?
Well, yes, ma'am. We don't really understand where it's coming from. We kind of had an agreement since last year. We actually completed a year lease. And what he told us, was pretty much that some money that was owed from last month, we had until June to pay it. And then he would officially give us the new lease. So we had already paid 2 months into the year. And, all of a sudden we get this letter in the mail saying that he wants to get his property that we wasn't supposed to be here. It's almost as if he wrote it up as we were squatters or something.
Mr. Boswell, no. We're not quite at the stage of taking testimony. My question was, do you have a defense to the landlord, to the termination case? What's your defense to the claim that he's entitled to return of his property?
Do you mean defense as far as like counsel?
I'm sorry?
Do you mean defense as far as like counsel representation?
What I mean is this is a termination of Tennessee case, and I'm prepared to swear you all in and take testimony from you this morning. Do you have defense to Mr. Moore's request to have his property returned to him is my question to you.
Yes, I do. I believe me and my fiance do. Yes, ma'am.
Okay. So then, Mr. Moore, do you have all documents and witnesses you need to conduct a hearing this morning?
What documents do I need? I have the ledgers as to the partial payments I was receiving. I have the lease agreement that expired in January 2020, January 1st, 2024. I have certificate of compliance. I'm not sure what do I need other than the
It's Mr. Moore, it's your case. I cannot help you put it on. And that's why I asked, do you have everything you need to have a hearing in the matter this morning?
Yes.
Same question to you, Mr. Boswell. Do you have all necessary documents and witnesses to have a hearing this morning?
Well, actually, my fiance has all the documents with her. She's at work. I'm here with our infant. So my hands are tied as far as documents and things, but she does have all that information with her, I believe. And it's a lot of this is text message. A lot of things is like verbal agreements, so everything is in. I don't know if we can provide text. I don't know if that's the thing. I know we do have it printed off. She does have it, but that is some of our documents as well that we were presenting.
If you're ready to proceed, give me one moment. There's a few other people from the 9:15 docket. If we can get them their matters called so we can make some time to take testimony. Mr. Hitchcock, I'm sorry to
Sounds-
interrupt you, but I wanted to call a few of your cases if we could, because we're going to start a short hearing. This is 2402283LT, BC Belleville Manor versus Phyllis Casper.
Yes, Your Honor. Good morning, Clifton Hitchcock, Swistack Levine on behalf of the plaintiff. Your Honor, there's a Ms. Lane who appeared who is not on the lease. She apparently has some ownership interest in the mobile home, but not the site lease. And I've had some discussion with her, and she's going to have some discussions with my client online. But we have
Sorry, everything went blank.
you're on with the court right now. I'm sorry, they pulled us over. You're on with the court. Why don't you identify yourself, Miss Lane?
I apologize. My name is Gianna Lane, and I reside at 187 Ponderosa Trail in the Belleville.
It's the discussion, Your Honor, has been because Miss Casper has not appeared, apparently no longer lives there, to take a default judgment against Miss Casper, and I can state the amounts and request on the record. And then Ms. Lane, I think, is going to have some separate conversations with our management off record.
The issue, thank you, Mr. Hitchcock. The issue that came up when we were here back on April 17th is that Ms. Lane is the occupant of the property. And is it, Ms. Lane, are you on lease for Belleville Manor?
No, ma'am.
No, she's not. I
Are
understand.
you authorized to be there, ma'am? I'm sorry. Mr. Hitchcock, what were you saying?
No, you were asking, Your Honor, is she authorized to be there? Is that what you're saying?
That's what I was asking when I was interrupted. Yes, sir.
I'm sorry, Your Honor.
Ms. Lane, are you authorized to be there?
As far as I'm concerned, no, they're saying that until I apply, that's what I'm working with the property manager to do right now, to apply, because I purchased the home from Ms. Casper with understanding that I would be able to live there and she will pay the rent, the lot rent. And she decided not to pay the lot rent anymore.
Your Honor,
Ms. Lane.
As she confirmed, she's not authorized.
Ms. Lane, respectfully, I'm sorry to interrupt you, but the issue here is that if you're not authorized to be there and you don't have a signed agreement with Belleville Manor or anyone else authorizing you to be on property, this court can't allow you to interject yourself in these matters. If you have an outside conversation with Desiree regarding making application to stay there, that's a separate conversation from today's hearing. The only named defendant in this case is Phyllis Casper. She has failed to appear now for a second hearing. This case was scheduled at 9:15. It's now 9:31 by this court's clock. Mr. Hitchcock, your request, sir.
Your Honor, plaintiff respectfully requests entry of a default judgment. There's currently rent to retain possession in the amount of $2,056.48, costs of $182.68, for a total of $2,239.16, which the defendant must pay in full or move out on or before May 13th, 2024. The writ may issue thereafter. No money judgment is sought at this time, Your Honor.
Thank you. Based on the named defendant's failure to appear twice in these matters, default judgment shall enter as requested by the plaintiff with a total amount of rent and cost due and owing of $2,239.16. Ms. Lane, this does not stop a conversation between yourself and Belleville Manor about making application. It just relates to Ms. Casper's financial obligation to Belleville Manor, okay?
Okay.
Okay, that concludes this matter, ma'am. You're free to go. You have a great day.
Okay, thank you.
You're welcome. This is 2402303LT. This is Belleville Manor versus Lisa Dufour.
Good morning, Your Honor. Clifton Hitchcock, Swistack Levine on behalf of the plaintiff.
Am I
Ma'am,
supposed
state
to
your
be?
name for me, please.
Lisa Dufour.
Thank you, Mr. Ford. Today is the day and time scheduled for the adjourned hearing in this matter. How are we proceeding this morning?
Your Honor, the parties have agreed to the terms of a consent judgment. There's currently rent to retain possession, $2,295.07, costs of $182.68, for a total amount of $2,477.75, which the defendant must pay in full or move out on or before May 13th, 2024. The writ may issue thereafter. No money judgment is sought at this time, and I've explained to Ms. DeFore her rights under 4.201J on 3-day right of rescission from entry of the judgment, 3 business days, to seek to set aside the consent judgment should there be anything she does not understand, although I've explained it clearly, and she's authorized me to sign a proposed consent judgment on her behalf and submit it to the court.
Thank you. Ms. Dufour, you were here back on April the 17th, and you saw the video that explained the rights you had available to you this morning.
Yes, ma'am.
Do you have any questions about those rights?
No, ma'am.
You were able to hear Mr. Hitchcock just place on the record the terms of a consent judgment,
Yes, ma'am.
and that's what you wish to agree to.
Yes, ma'am.
And you authorized him to sign your name to that document.
Yes, ma'am.
Do you have any questions about today's proceedings?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Then Mr. Hitchcock's office will prepare that consent judgment. He will file it electronically with the court. I will sign it, and a copy will be mailed to you at the address we have on record. Is there anything else in this matter, sir?
No, Your Honor, thank you.
Anything from you, Ms. DeFore?
No, ma'am.
That concludes this matter, ma'am. You're free to go. You have a great afternoon.
You too.
Thank you. This is 2402338LT. This is George Robinson versus Teddy Robinson.
It's George Robinson.
Thank you. Mr. Robinson, when we were here last week, April the 24th, the other Mr. Robinson failed to appear, and I asked that you file proof of service with the court. Mr. Teddy Robinson has failed to appear this morning, and this court did not receive proof of service. How did you intend to proceed this morning, sir?
Could I get another adjournment? We're trying to talk this out.
I appreciate that. That will be May the 17th at 9 a.m. And we'll mail notice out with that date and time. Okay, we'll be back on the same Zoom at 9 a.m. on May the 17th.
Thank you, Your
Is there
Honor.
anything else, Mr. Robinson?
No,
Have a good day, sir.
thank you.
You're welcome. Mr. Hauser and Mr. Ween.
Good morning, Your Honor.
Good morning. Have you had the opportunity to speak?
We have, Your Honor.
And Your
This
Honor,
is
I am,
240.
sorry, I just wanted to say I'm representing Mr. User.
Oh, I didn't see an appearance when I went through these on Monday.
We filed it yesterday, I believe.
This is 2402432LT. This is Tomahawk Ventures versus, it says occupant in the caption, but your appearances, please.
Good morning, Your Honor. Eric Wine for the plaintiff, P56893.
And good morning, Alexa Metner from Lakeshore Legal Aid, on behalf of the occupant, who is Mr. Ronald User.
Good morning. How are we proceeding in this case?
Your Honor, we're in need of a hearing.
9:45 on May 17th.
How about today, Your Honor?
How about today?
Yeah, we're ready to proceed. This is a foreclosure after a sheriff's deed. This is the second hearing.
Sir?
Yes, ma'am.
Sir?
Yes.
Ms. Methner, are you ready to proceed this morning?
I can, Your Honor.
Okay, listen, let me get through the rest of this docket. There's only a handful of cases. So if you want to go into a breakout room and talk, or if you just want to go dark, when I get done with the rest of these, I'll get your case called, okay?
Thank you, Your Honor.
Thank you.
Thank you. This is a recall of 2401385LT, Moore, Boswell, and Liggs. If the three of you already have your appearances noted, if you would raise your right hands, do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
Thank you. You may put your hands down. Mr. Moore, it's your case. Please proceed.
Okay, Your Honor, we started a landlord-tenant agreement back in January 1st, 2023, and that lease agreement lasted for a year. It lasted for a year, January 1st, 2024. At that year, end of that year, Mr. Boswell and Ms. Liggs were behind a substantial amount of money, and I informed both Ms. Liggs and Mr. Boswell that that $2,600 was to be paid by June 20th, 2024. I also added with that, Your Honor, that if that amount increased, that I would pursue a eviction, and that I was not going to reverse my decision with that. They did pay in the month of January and in the month of February. In the month of March, for some reason, there was no rent paid. In the month of April, there was no rent paid. I'm not seeking any money or any money damages. The only thing I'm interested in as a landlord is to ask that Mr. Boswell and Ms. Liggs vacate the premises.
Is there anything else, Mr. Moore?
No, Your Honor.
Thank you. Mr. Boswell, do you have any questions for Mr. Moore? This is not your testimony. This is questions to him.
No, I don't. Not to what he just said.
Thank you. Ms. Liggs, do you have any questions for Mr. Moore?
I don't, not to what he just said.
Thank you. Anything else, Mr. Moore?
No, Your Honor.
Any other witnesses, sir?
No, I don't have any, no.
Thank you. Mr. Boswell, your testimony, sir.
Okay, everything he said is factual as far as the lease agreement and everything like that. The reason we were behind that amount was there was friction after about 4 months of us paying here. We started getting letters on our door about foreclosure notices and things like that. People was coming by taking pictures of the house, so we kind of like mentioned that to him, like, hey, this is going on. So he's like, I don't worry about it, it's taken care of, So I think about another month or so we paid, and the same thing kept happening. And my children's grandmother actually seen on site that the house was listed, had a auction date on the site. So we mentioned it to him again. We were pretty much waiting for proof. We didn't submit any money because he wasn't giving us proof. It was a runaround. So that was the standstill. Eventually he did give us proof showing that he had got it paid. And that's when we would, we came up with an agreement. We was like, look, that's a lot of money that, we kind of messed up. We messed up by not, escrowing it out or whatever. It's not that we wasn't able to pay rent, because that same month when we had that conversation, we picked up where we left off. He just told us that, look, this was in November, actually, when our lease was almost up. He said, listen, if y'all can just take care of what y'all owed for those few months, by June 20th, I will, give you the other lease. Right now, we'll just do month to month. And he told us if that amount increased, that amount didn't increase. We were late in March. We didn't pay in the month of March, but the reason we didn't pay in April, like he just stated, was we got the court papers on our door, the summons, I believe was dated April 1st, I believe. So we were actually late on March. We were going to be late on March, but it to say that amount increased, that wasn't the case. That wasn't factual. So what we honestly feel is like he got the $2,000 that he was asking for. That he said he would hold off for that till June. We feel like since we paid that in January, February, now it was like he just wants us to get out. So that kind of put us in a bad predicament. If we would have known that, we would have came up with a whole nother plan. We wouldn't have had to stay here. We wouldn't have. We just had a baby. So to kind of trap us in that situation, we thinking, all right, look, we got till June to pay this money. We pay you $2,800 January and February, and now you want us to leave. So I just don't think that's fair. I feel like we should have a little more adamant time to figure out, our end. And I'm not
Anything
sure
else,
if
Mr.
Caprice wants to.
Boswell? Oh, I'm sorry, go ahead.
Say it again. I'm sorry. No, I was actually going to suggest something else, but I'm sorry. There's nothing else.
No, you're fine. Mr. Moore, do you have any questions for Mr. Boswell?
No.
Thank you. Ms. Liggs, your testimony. You're muted, ma'am.
I'm sorry. So Bernard, he pretty much said everything. I don't want this to be long and drawn out and, pretty much say everything over, but it has been very shaky since we moved in. He did promise us till June. The reason why the house was never registered as a rental. So he had to actually get it registered as a rental. So when he realized that it wasn't, he pretty much told us that we didn't have to pay him until June. Also, we were getting notes. We got a note in the mail from the homeowners association that they actually wanted us to pay them, give us the money that we pay for rent. And we pay a lot of money. So I was kind of iffy about giving it to them because I didn't know how legit it was, because he had lawyers call us before that were very nasty towards us and everything. So this is a letter that we got saying that we had to pay the homeowners association. This is why he gave us until June. June hasn't got here, so I don't believe that it's fair that we should. Well, I want to leave. I'm not saying that I want to stay, but I think that we should still have a fair case because it's not fair. And the letter that we got in the mail saying that we actually have to leave is saying because the lease is up. We knew the lease was up, but he gave us until June. That's why we were still there. So it's not like we're there and the lease, was just up and we're just staying there. This is a stack of mail that I still have that he was supposed to pick up. This is all foreclosure, homeowners association. It's been very stressful. I just had a newborn baby in January, so I've been out of work and he was aware of that. And from what we know, he's been working with us. So everything's kind of up in the air. We're not trying to stay, but we really, honestly, we just want a fair case so that this doesn't happen to anyone else, because it has been very shaky since we've been living there.
Anything else, ma'am?
Nope.
Mr. Moore, do you have any questions for Ms. Liggs?
Well, not so much some questions, but I have some answers for both Mr. Boswell and Ms. Liggs.
Wait, sir, if your response to my question is no, you don't have any questions for her.
I don't have any questions.
Ms. Liggs, is there anything else?
Let me think before I speak too fast. This is going to be the last case. I know last time when we spoke, and we went into a private room, you did tell us that we didn't have to give you any money. I didn't know that this was going to be adjourned to where we were going to still be staying there while we're finding the place. I know you said we didn't have to give you any money. I'm okay with that. But as far as our security deposit, I kind of want to know where that plays out. Because you want us to leave, but you've never done anything. Well, he's never done anything that was promised. Our carpet is filthy nasty. And my kids aren't even able to play on the carpet. He has been promising us that he was going to do the carpet since we moved in there. He's still never done it. He was supposed to come April 20th, but we got a letter saying we have to go to court. But I do feel like we should at least get our security deposit back, because you want us to leave. Everybody knows it's not easy to find a place. Everybody knows that a security deposit is going to be high. Ours was only $1,000 because the carpet was nasty. And you still haven't fixed it. So I feel like if you want us to leave, at least let's be fair and put us in a position to where we're able to put down a $3,500 deposit to move in somewhere, because that's what it's going to be. I have been looking. I wouldn't want to stay there, especially with a situation like this with the landlord. I guess we're in a really bad position, and I just want a fair case. Not that we're not trying to leave, because we are going to leave, but we do want our security deposit back so that we can put it up somewhere for us to move somewhere else.
Anything else,
And if
ma'am?
not, no, that's it.
Anything else, Mr. Moore?
Okay. I'm not sure. Well, I am sure. There is no security deposit. They're in the rearatures of over $5,000. So your security deposit, that there is no security deposit. I was crystal clear as to getting rugs clean and everything else. And they did. The bottom line is that they're not paying their rent. I'm not upset. It's not personal. This is business for me. They're not paying their rent. They've been very poor. They've been very poor tenants since they've been there. I need to really just get them out of there as soon as possible. I'm renting the place to get money. That's why I'm renting it. So I need to get them out of there. I'm just going to sell the place, fix it up, and I'm just going to sell it. I'm not even going to rent it anymore. So I'm done with it. Like I said before, if they found somewhere to go or if they plan on leaving, then do that. Do that. Let's just get a vacate date so we both can just part our ways.
Anything else, Mr. Moore?
No, that's it, Your Honor. And the house is not in foreclosure and it's current, and so.
Thank you. The court has had the opportunity to hear from the parties this morning, and the court did review the file in this matter. There was a notice to quit that was served upon the tenants on February 22nd, 2024, directing them to vacate the premises by March the 25th, 2024. When they did not vacate, the plaintiff filed a complaint that indicates that he's requesting return of the property as the lease has expired. The testimony of the parties this morning confirms this information. The court will find that Mr. Moore is entitled to recover his property. Statutorily, Mr. Moore, you have to allow them at least 10 days to vacate the property. So if you will prepare a default judgment, a judgment after hearing that finds in your favor and sets their date to vacate the property at least 10 days from entry of the judgment, the court will sign that. Ms. Liggs, the court is not ignoring your question regarding security deposit and would suggest that you either speak to a representative from Lakeshore Legal Aid who might be able to give you some advice this morning, or you can go on michiganlegalhelp.org. It explains to you your obligations as a tenant when you surrender the property back to Mr. Moore. Was there anything else, Mr. Moore?
You said that I have to file an additional default or something. I thought I heard you say. Or?
I said default and I misspoke, sir. It's a judgment after hearing. It's a judgment form, and there's a box that you mark that it's after hearing that you're entitled to recover the property.
Okay, it's called the judgment after hearing.
There's a member of the court staff, sir. I'll move you into a breakout room. They'll help you locate the form on the court's website that you need to submit, okay?
Okay, thank you, Your Honor.
Yes, Mr. Boswell. You're muted, sir, before you start talking.
I just wanted to clarify something you said when you spoke. You said that we had got a letter for a notice to quit in February, and then you got a follow-up notice. Does the court see that after with the notice to quit, the check was deposited about 3 days later? So the notice to quit was wiped out. Do y'all not see that? Because it sounds as if you see it as it was a notice to quit, we didn't pay. So then the demand for property came back out, and that's not the case. When the notice, we spoke with him after the notice to quit, we spoke to him like, hey, why did we get a letter about a notice to quit? We paid you. He said, oh, I do that to all my tenants. You know, I didn't know what was going on. Y'all was late. If my tenants are a couple of days late, I always send a notice to quit out. He was like, y'all just let me know if y'all gonna be paying late. So I want you to know that the date that you're speaking of, February, whatever, that the notice to quit came out, we deposited a check that day. So I just wanted to clarify that. Not that day, but I believe like 2 days later, I believe it was. So you should see that. And it was before the date that was posted on that paper. I just don't understand how the court doesn't see that.
And could I say something if I'm able to?
Mr. Boswell, understand that the court can only go by what's filed. There's nothing filed that says that.
Oh, okay. So is it, so it's almost as if he's lying. I mean, it's the notice to quit was taken care of. If we paid it before that date on that paper, the notice to quit should be like wiped out, correct?
The notice to quit is to vacate the property. It's not about the past due rent.
But I thought that it wasn't about us paying a certain amount by this date, or we had to vacate. I think I have that paper. Let me see. I think I have it with me.
I think I have.
If I'm
Mr.
not mistaken.
Boswell, it's
Yes.
demand for it was the notice to quit to recover possession of property. Nowhere on here is there anything about money. It's indicating that your landlord wants you to move from the property.
Yes, you're right. I'm looking at the wrong paper. I'm sorry. I'm actually looking at the wrong
Okay.
paper. You're right. I see it. I see it here. Notice to quit to recover possession of. I see it.
That concludes this matter. Mr. Moore, did you want to speak to the court staff about that form?
Yes, please, Your Honor.
We'll get you moved into a breakout room with either Sandy or Dan. Other than that, that concludes this matter.
So, okay, I have a question.
Yes, ma'am.
So where does that leave us? I heard you say something about 10 days. Does that give us 10 days or still waiting for us to get them that will be paid? I have a whole
Your
family,
audio
so I
is
kinda-
breaking up. I'm
before we-
sorry. You said,
I'm
do
sorry,
you
are
have?
you able to hear me?
Yes.
Yeah, so is there a certain set date that we have to leave, or how will we figure that out? Only because I have a family and I want to make sure that I know exactly what we have to do.
I understand that, Ms. Liggs, and at the minimum, the judgment will indicate that you need to vacate by May the 13th.
Okay. So is that the day we have
Okay.
to leave? We have to be out. We have to have all our stuff out by May 3rd.
Correct.
It's dirty. That's cold.
Are we able to obtain a lawyer?
Are you able to obtain?
A lawyer on our own, since we don't actually, or we
Jury
don't, we're not
trial.
approved for a legal aid. Because May
You're always
13th,
able
that's,
to,
I'm sorry, go ahead.
no, you go ahead.
May 13th, that's kind of like really close. I have 2 children and a newborn, which he knows about. So I kind of need a little more time than May 13th, but definitely by the end of May, we could be out.
Oh,
But May 13th, that's
Miss-
kind of,
Ms. Liggs, the issue is that the court took testimony. The court asked the parties were they able to proceed, ready to proceed, and the finding has been made. You can always retain an attorney in any matter. There's nothing that prohibits you from doing that. But today's hearing will result in the judgment once it's filed by the plaintiff. If you reach some other agreement with Mr. Moore, that's between you and Mr. Moore. This court's part of this process is concluded. Was there something else, ma'am?
nope.
And ma'am, good luck to you. Have a good afternoon. This is a recall of 2402432LT. This is Tomahawk versus Hauser.
Good morning, ma'am. Again, Your Honor, Eric Wine for the plaintiff, P56893.
And Alexa Metner for the defendant.
Were we ready to proceed?
Yes, Your Honor.
Yes.
Sir, you have all necessary documents and witnesses?
I do, Your Honor. There's a sheriff's deed that accompanies the file. This is an action for possession following the termination of the redemption period in late March. The sheriff's sale took place in September of 2023.
Sir, thank you. I've reviewed the file. Ms. Methner, you have all necessary documents and witnesses?
Yes, Your Honor.
Thank you. Now, sir, sheriff's sale?
Yes, Your Honor. Are you asking me when it took place?
I'm ready for your case. Yep.
All right, Your Honor, this is an action for possession following the expiration of the redemption period on a mortgage foreclosure sale. The sale was conducted by the Wayne County Sheriff on September 28th, 2023 for the property on Haggerty that's at issue. Mr. Hauser apparently is the occupant of the property and did not redeem. And at this time, we are asking for possession.
Anything else, sir?
No, Your Honor.
Ms. Methner?
Yeah, Your Honor. Mr. Hauser has lived at this house all his life. At the beginning of the redemption period, he had reached out to the new owner who asked him to stay during the 6 months. He took this to mean that they were going to be able to work with him to try to keep the house or at least allow him to continue staying there. Unfortunately, when he tried to reach out again, communication ceased in favor of evicting him immediately after the redemption period. At this point, we don't have a legal argument as to why he should stay. We are just asking the court to use its equitable power to maybe give him more than 10 days. He is waiting on an application for a new place. He also has no one to help him move his things and is currently going through cancer treatments. He's just asking for a little bit more than 10 days so that he can remove his things and secure housing.
Was there anything else?
No, Your Honor.
How much more than 10 days?
He would be asking for 2 weeks.
Did the two of you discuss this in a breakout room?
We have, Your Honor.
Your client is unwilling for 14 days, sir?
Oh, Your Honor, that hasn't been requested of me. We discussed a different solution to the situation. I can agree to 14 days.
Okay. That's correct then, Your Honor. It was my understanding they weren't willing to give any more time, but if you are able to give 14 days, then we would agree to that.
We got a deal.
14 days puts us at Mr. Hauser vacating the property owner before May 15th. Sir, if you will prepare a judgment with that indication on it, file it by my file, the court will sign it.
Thank you, Your Honor.
Was there anything else on behalf of the plaintiff?
No, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor.
Thank you. That concludes this matter. Have a good afternoon.
You as well.
Thank you, Your Honor. Have a good afternoon.
Thank you, sir. You too. Good luck to you.
Thank you.
This is 2401379LT, Aaron Sellers versus Leonard Campbell and Danielle Campbell. May I have your appearances, please?
Leonard Campbell.
Good morning, Your Honor. George of Lakeshore Legal Aid on behalf of the Campbells.
Good morning,
State
Your
name for
Honor.
me,
Aaron
please,
Sellers.
Thank you, Mr. Sellers. Today is the day and time scheduled for the adjourned hearing in this matter. The parties have had the opportunity to speak. Mr. Sellers, how are we proceeding?
I guess I mean, at this point, I would like to be paid, but I also would like to bring it up to the courts that they have broken the lease by, I don't believe they actually live in my house. I believe their son is living in my house. I've driven by the house several different times. Their car's never there. It's always their son and 3 or 4 kids that are not on the lease, as well as a big pit bull that they've initialed and signed in the lease stating that there's no animals on the property. So at this time, I don't even believe they're living in the property. I believe it's their son, and the amount that they owe me keeps going further and further in the rears. And I have mortgage payment on the property that I haven't been able to make. So I'm getting negative impacts on my credit.
Mr. Sellers, I'm sorry. You spoke to Mr. George this morning regarding this case?
All he told me was he was trying to get an extension for 2 weeks, and I told him I didn't agree to that. That was the only conversation that we had, ma'am.
Thank you. Mr. George.
Yes, Your Honor. The Campbells have applied for state emergency relief. We filed the DC 539 with the court within the 5 days. So we would just request that the court enter a 2-week stay pursuant to the court rules. I would
Thank
also
you.
note that
Mr. Sellers.
I
I'm
would
sorry,
al-
go ahead, Mr. George.
I would also note that this is a non-payment of rent case. I don't believe that there was anything in the complaint about any other lease violations.
Mr. Sellers, when we appeared back on April the 24th, there was the indication that there was going to be or had been an application for rental assistance. The court did review the file and the DC 539 was filed. The court is required to adjourn this matter one last time. That adjourn date will be May the 17th at 9:15 a.m. We will be back on this same Zoom ID number. Court staff will mail notice of that new date and time to you at the address we have on record. Was there anything else, Mr. Sellers?
You said May 17th at 9 a.m.?
9:15, sir.
Okay.
Anything else, Mr. George?
Your Honor,
I'm sorry.
I do
hold
have
on.
one.
Go ahead, Mr. Sellers.
I do have one more thing. I'm getting cancellation notices of no power at the property as well from DTE. And I haven't had a chance to check with them, but it's a renter landlord account. So I think at this time, the account has actually reverted back to myself. I have to get clarification of that, but DTE did send me a notice to shut off power for non-payment at at my property.
Excuse me, Your Honor. Excuse me, Your Honor. This is Leonard Campbell.
Hold on. Mr. Campbell, hold on one second.
I have taken care of the DTE.
Mr. Campbell? Mr. Campbell, hold on one second, please. Mr. Sellers, were you done with your statement, sir?
Yes, ma'am, I am.
Mr. George, anything?
Yes, Your Honor. I'm not sure yet if I am going to be if I'm going to want to file an amended answer. So just to make sure that I'm covered, I'd like to request leave to amend the answer.
Any objection, Mr. Sellers?
I'm sorry, I've asked for legal help from the court on the last one. Once he got legal help, I don't understand what that means.
Mr. George has asked the court for permission to amend his answer, which means supplement it in some way. And the court did not ignore your previous request for an attorney, but the court only sends out the information regarding legal services that are available. And I thought our conversation last time was that if Lakeshore is representing a tenant in the case, they are not going to also represent the defendant. They have a conflict in that representation that I don't think they can resolve. So you have the opportunity, if there's another legal services organization you want to contact, or if you want to have a consultation with an attorney, a private attorney, to see if they're able to assist you or give you some guidance, that's always available.
I can't afford attorney, ma'am.
Understood. Anything else as relates to today's proceedings, Mr. George?
If the court could just clarify, was leave granted?
Yes, sir.
Thank you. That's all.
And the issue that Mr. Sellers raised regarding the cutoff of insurance, Mr. Campbell was trying to say something. If you might want to go back into a breakout room with him to have that conversation, I don't know if that's necessarily something we need to have on the record. But if there is the non-payment of utilities and the tenants are responsible for it, let's not make a non-payment case increase in terms of what's owed to Mr. Sellers, okay?
Yes, Your Honor. Mr. and Mrs. Campbell, I will follow up with you either this afternoon or sometime tomorrow, and we'll talk this out, okay?
Yes, sir. Thank you, Mr. George. Thank you.
Thank you.
And you have Mr. Sellers' contact information, Mr. George?
Yes, I have his email address.
Okay. Other than that, that concludes this matter. This court will see the parties back here on May 17th at 9:15 a.m. Have a good afternoon.
Thank you.
Thank you.
This is 2402440 LT, Huron Estates versus Carol Henderson and Holly Henderson. Would you state your names for the record, please?
Good morning, Your Honor. Clifton Hitchcock, Swiss Stack Levine on behalf of Huron Estates.
And where is Carol Henderson?
She's at another doctor's appointment.
The parties have had the opportunity to speak. Mr. Hitchcock, how are we proceeding this morning?
Ms. Holly Henderson and my client have agreed to the terms of a consent judgment. There's rent to retain possession.
I'm sorry, Mr. Hitchcock. Ms. Henderson, there was a DC 539 file showing that you made application for rental assistance with DHS. Does that application remain pending?
Yes, it still has remained pending. I haven't heard anything back other than they had wanted proof of income, which I had just sent over this morning.
Is there a reason why this case should not be stayed further, Mr. Hitchcock?
Well, because Ms. Henderson intends to use the this consent judgment with the increased amount, including rent, in terms of her assistance, and my client, will judiciously wait to see what happens with her application. So my client's working with Ms. Henderson, actually both of them, but I don't know that it merits further adjournment because she agrees to the terms, and this is a way to resolve this, but also to give her something to expedite funds being received for that.
Ms. Henderson, because your application remains pending, the way the court rules are written allows an additional adjournment of this matter. Do you wish this matter to be adjourned to May 17th, or do you wish the court to adopt terms of a consent judgment that you negotiated with the attorney?
The first option, the one that you just said, the first one.
To adjourn this matter?
Yes.
May 17th at 9:15.
Yeah.
Court staff will mail out notice of that new date and time.
Thank you.
The greater issue, Ms. Henderson, is that the other Ms. Henderson, Carol Henderson, is technically in default. This is her second failure to appear.
Yes, I know.
Okay.
Your Honor,
If there's nothing else, ma'am, you're free to go.
Okay, thank you.
I'm sure you'd prefer they line up.
I'm sorry, wait.
It's okay. It's
What are
okay.
you saying?
I'm good on it, Your Honor. That's fine.
You sure?
Yes.
Thank you. 2402444 LT, Huron Estates versus Darren Maynard.
Hello.
Morning, Your Honor. Clifton Hitchcock, Swiss Stack Levine on behalf of Huron Estates.
State your name for me, sir.
Darren Maynard.
How are we proceeding this morning?
Your Honor, the parties have agreed to the terms of a consent judgment in which Mr. Maynard agrees to pay rent to retain possession in the amount of $1,583.80, costs in the amount of $182.68, for a total amount of $1,766.48, and pay that amount in full or move out on or before May 13th, 2024, or the writ may issue thereafter. No money judgment is sought at this time. I've explained in detail Mr. Maynard's rights to him with respect to 4.201J and the 3 business day right to rescission to approach the court to set aside the judgment should there be anything included in it that he did not understand. He's authorized me to sign the consent judgment on his behalf and submit it to the court.
Thank you. Mr. Maynard, were you able to hear Mr. Hitchcock just now indicate the terms of the consent judgment that you reached with him in the breakout room?
Yes, Your Honor.
And is everything he said correct and accurate, sir?
Yes, it is.
And you were here on April the 24th when the video was played that explained the legal rights you had available to you this morning.
Yes, ma'am.
Do you have any questions about those rights?
No, ma'am.
Do you have any questions about the consent judgment?
No.
Then Mr. Hitchcock's office will prepare a consent judgment that indicates that you'll pay a total of $1,766.48, on or before May 13th, 2024. He will sign your name to that document, file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of the plaintiff?
Thank you for your time, Your Honor.
No, nothing.
Have a
for
good day,
plaintiff.
sir.
Thanks.
Thank you, Mr. Hitchcock. This is 2402447 LT Huron Estates versus Matthew Sandy and Ruth Sandy. Would you state your names for me, please?
Matthew Sandy.
Ruth Sandy.
Clifton Hitchcock on behalf of the plaintiff, Your Honor.
Thank you. Today was the day and time scheduled for the adjourned hearing in this matter. Mr. Hitchcock, how are we proceeding?
Your Honor, the parties have agreed to the terms of a consent judgment by which the defendants agree there's rent to retain possession in the amount of $3,715.82, costs in the amount of $233.71 for a total amount of $3,949.53 that the defendants agree to pay in full or move out on or before May 13th, 2024. The writ may issue thereafter. No possession, no money judgment, rather, is sought at this time. I've explained in detail the rights, including under 4.201J, the 3-day business court day right to rescission on the judgment, should there be terms within the judgment that they do not understand, as they're not represented by counsel at this proceeding. They've agreed to those terms. They've authorized me to sign each of their names to this consent judgment and submit it to the court for entry.
Thank you. Mr. Sandy, Ms. Sandy, you were able to hear the attorney just now?
Yes. Yes.
And do the terms of the consent judgment that he placed on the record accurately reflect the conversation you had with him in the breakout room?
Yes. Yes.
And you were present back on April the 24th where the court played the video that explained the legal rights you have available in this landlord-tenant case?
Yes. Yep.
Do you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No.
Then his office will prepare a consent judgment. He'll sign your names to it. He will file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. If there's nothing further, you're free to go. You have a great afternoon.
You do the same.
Thank you. Thank you. This is 2401540 LT West Village Estates versus Brittany Pankow. Your appearances, please.
Good morning, Your Honor. Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff, West Village Estates.
Trisha Prutnick, Your Honor, on behalf of Ms. Pankow.
Today was the day and time scheduled for the adjourned hearing in this matter. This case had been reinstated. How are we proceeding this morning?
Your Honor, with respect to Mrs. Brittany Pankow, the parties have agreed to the terms of a consent judgment. There's currently rent to retain possession in the amount of $4,275.22, costs in the amount of $231.71, for a total amount of $4,506.93. That must be paid in full, or Mrs. Pankow, the defendant, must move out on or before May 19th, 2024, or the writ may issue thereafter. Mr. Pankow has not appeared in these proceedings and is not represented by Ms. Prutnick, so I would seek a default judgment as to Mr. Pankow, same terms. I should further add that as a term of this consent judgment, if Mrs. Pankow satisfies the terms of this judgment, it shall be set aside. And that is stated in the consent judgment. No money judgment is sought at this time, and I've received permission to sign and submit this proposed judgment on behalf of Mrs. Pankow and submit it to the court today.
Ms. Prutnick.
That's correct, Your Honor. The terms are accurate.
Thank you. The court has made notes regarding the consent judgment. Court will await receipt of it. Is there anything else, Mr. Hitchcock?
No, thank you, Your Honor.
Anything else, Ms. Prutnick?
Nothing further, Your Honor.
Thank you. Ms. Panko, you're free to go. You have a great afternoon. Good luck to you.
Thank you, you too.
Thank you. This is 2402433 LT Huron Estates versus Amanda Atkins.
Good morning, Your
Ms.
Honor.
Atkins, unmute. I'm sorry, sir.
I'm just saying Clifton Hitchcock on behalf of the plaintiff.
It's that 2-second delay. It's killing us. Ms. Atkins, unmute yourself and state your name for me, please. Ms. Atkins.
Amanda, unmute. Hit the red microphone. Okay.
Hi.
Hi, today is the day and time scheduled for the adjourned hearing in this matter. The parties have had the opportunity to speak. How are we proceeding, sir?
Your Honor, the parties have agreed to the terms of a consent judgment. There's currently rent to retain possession in the amount of $2,714.93, cost in the amount of $182.68 for a total amount of $2,897.61, which the defendant, Ms. Atkins, agrees to pay in full or move out on or before May 13th, 2024, or the writ may issue thereafter. No money judgment is sought at this time. I've explained her rights under 4.201J with respect to if there's anything in the judgment she does not understand, approaching the court and bringing a motion to set aside said judgment within 3 business days of entry of the judgment. Ms. Atkins has authorized me to sign the judgment on her behalf and submit it to the court.
Thank you. Ms. Atkins, were you able to hear the attorney just now?
Yes, and I was wondering if I can have more time because I have jobs coming up. So I don't know if I want to go with that. I have a job today to go start 600. I have another job to start that after that one 600. And I just want to make sure that I'm not going to be evicted because I'm working on it really hard to get the money.
Your Honor,
Did you discuss more time?
no, we haven't. If we need to discuss this a little
Yeah,
further,
that's just-
we do have our property manager I see is on the Zoom. So if she could be sent back to, the waiting room for Levine or meeting room, then and Ms. Atkins, I think we can probably, discuss this in very short order.
Is it with Jessica D?
Yes, yes.
We'll get Jessica D and Amanda Atkins moved into a breakout room. We'll call your last case, Mr. Hitchcock.
Thank you.
This is 2402435 LT Huron Estates versus Sarah Cermak and Austin Gutierrez.
Good afternoon, or good morning, Your Honor. Clifton Hitchcock on behalf of the plaintiff.
State your name, please, sir.
Austin Gutierrez.
And sir, do you know where Sarah Cermak is?
She doesn't live on the property anymore. I just haven't got her name off the lease.
Okay. You've had a chance to speak to the attorney this morning?
Yes, I have.
How are we proceeding, Mr. Hitchcock?
Your Honor, Mr. Gutierrez, and my client have agreed to the terms of a consent judgment, but there is currently rent to retain possession in the amount of $2,467.24, costs in the amount of $233.71, for a total amount of $2,700.95, which Mr. Gutierrez must pay in full or move out on or before May 13th, 2024, or the writ may issue thereafter. There's no money judgment is sought at this time. I've explained in his rights under 4.201J with respect to the 3 business day right of rescission to request that the judgment be set aside if there's something that he did not understand within the judgment being entered today. As Your Honor heard, the other defendant, Ms. Cermak, it's not appearing in this matter, so I would request entry of a consent judgment as to Mr. Gutierrez and a default judgment, same terms as to Ms. Cermak.
Mr. Gutierrez, does that accurately recite the terms of an agreement that you reached with the attorney in the breakout room?
Yes, it is.
And sir, you were here on April 24th when the court played the video that explained the legal rights you have available to you in this matter.
Yes, I was.
Do you have any questions about those rights, sir?
No, I don't.
Do you have any questions about the consent judgment?
Nope.
Do you have any questions about today's proceedings?
Nope.
Then his office will prepare a consent judgment with the terms that were placed on the record. It will appear as a default as to Ms. Cermak. I understand you said she moved out, but as a technical wrapping up of this case, it will show as a default judgment. He'll sign your name to it, file it with the court. The court will sign it, and a copy will be mailed to you at the address we have on record. Is there anything else, sir?
Just because there's a default judgment on her name, I still have until the 13th, right?
Yes, sir.
All right, that's fine.
Thank you. You're free to go. You have a good day.
All right, you too.
Mr. Hitchcock, before you go, I just want to thank you for how complete your recitation of these agreements have been when you come out of the breakout room explaining the 4.201J more thoroughly than most attorneys do. I appreciate that. Thank you, sir.
Thank you. My pleasure. Thank you, Your Honor.
And when you're ready with Ms. Atkins, Mary Ann will let me know and I'll come right back out, okay?
Thank you so much. Thank you.
You're so welcome. Thank you.
Hello.
Yes, yes, sir. I know.
I left the room. I didn't mean it. Is what?
We're back on the record in 2402433 LT Huron Estates versus Amanda Atkins. The court had taken the terms of a consent judgment. There was to be some conversation about the writ date. Mr. Hitchcock.
Yes, Your Honor, the parties have had further discussion and the parties have agreed to the terms of a consent judgment. Again, there's rent to retain possession in the amount of $2,714.93, costs of $182.68, total amount $2,897.61. We've provided the defendant, Ms. Atkins, will have until May 31st, 2024 to pay that amount in full or move out by May 31st, 2024. As a further proviso, which would be included in a consent judgment, that defendant agrees to pay $1,200 of the total judgment amount by May 13th, 2024, with the balance to be paid by May 31st, 2024. Explained MCR 4.201J to Ms. Atkins, 3-day right of rescission. If she's not represented by counsel, she'd have up to 3 court days from date of entry of the judgment to approach the court and bring a motion to set aside the judgment if there was anything she didn't understand within the judgment, but I believe she does. She's authorized me to sign the judgment on her behalf and submit it to the court.
Thank you. Ms. Atkins, you were able to hear the attorney just now?
Yes.
And is everything he said accurate?
Yes.
And you were here on April 24th when the court played the video that explained the rights you have available to you in this landlord-tenant matter?
Yes.
Do you have any questions about your rights, ma'am?
No, I don't.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No.
Then Mr. Hitchcock's office will prepare a consent judgment that indicates that you owe a total of $2,897.61. It will contain a further order that you pay $1,200 by May the 13th and the balance by May 31st. He will sign your name to it, file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. Was there something you wanted to add, ma'am?
No, thank you.
Thank you. That concludes this matter. You're free to go. You have a great afternoon.
Thank you, Your
You
Honor.
too. Thank you.
You as well.
That concludes this court's docket for the day. Thank you all. Have a good afternoon.
Thanks so much, Judge Martin. Have a good day. Bye.
You're
Thank you, Your
welcome.
Honor. You do the same.
Thank you, Mr. George.